Hello and welcome. I'm Amritan Shirai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Prevention of Corruption Amendment Bill 2013. To discuss the issue, I have with me Mr. Shakti Sinha, former public servant, and Mr. Vishwanathan, senior advocate and former additional solicitor general. Now for the headlines. Bribe giving and taking in all its forms to be made a criminal offence. Parliamentary Standing Committee asks the government to define corruption and corrupt practices. The committee recommends government to include retired officials in the definition of public servants. Bribe giving is likely to be criminalised in all situations. The Prevention of Corruption Amendment Bill 2013 has redefined criminal misconduct and modified penalties for offences related to taking bribe so that it can be made a criminal act.
According to the statement of objects and reasons of the bill, the government intends to amend the bill to synergize the Indian laws on bribery with the United Nations Convention Against Corruption, the international practice on treatment of the offence of bribery. India has ratified the UN Convention. In order to do this, a review of existing provisions of the Prevention of Corruption Act 1988.
The amendments which have come in this particular bill, they are pretty much targeting the bribe givers in terms of corporate houses. And the specific amendment, if you have read it, it is basically that earlier in the previous amendment, it was if somebody X person gives a bribe, then the entire organization's top management can be taken to task. Now basically it has been put a little bit in a dilution state in the sense if it can be attributed to a senior officer. Earlier it was collectively everybody will be held ransom, but now it will be more if you can prove that this can be attributed to a particular officer. So from that perspective, this particular amendment is okay.
According to Prevention of Corruption Amendment Bill 2013, a public servant takes a bribe if he asks, expects, accepts or attempts to obtain any gains in exchange for the improper performance of a public activity on his own. The existing law protects the bribe giver if he gives a statement in the court of giving bribe, but the bill removes this protection. It changes the definition of criminal misconduct to include fraudulent misappropriation of property entrusted to him. Habitual offenders are now defined as convicted public servant who has subsequently committed an offence. For such persons, punishment has been enhanced. The bill empowers the investigating police officer to confiscate the property of a public servant accused of an offence. In order to do this, approval from a special judge with prior government approval will be required. The bill extends prior approval for retired public servants.
First, commercial organizations have been now introduced for the first time as being responsible if some of their employees indulge into corrupt practices. The second good point is Chapter 4, Capital A, where there are provisions made and stringent provisions made for attachment and forfeiture of property which has been accumulated by corrupt means. So that's a completely new chapter which I think will benefit the fight against corruption.
The existing law penalizes taking of a bribe through intermediaries and third parties. The bill covers bribes that are given to an intermediary or given through a third party. The existing law covers bribing in business transactions. The proposed changes are that commercial organizations will be held guilty of giving a bribe to a public official if it offers any gratification in return of obtaining advantage in business. The Prevention of Corruption Amendment Bill was introduced by Shri V. Narayan-Swamy, Minister in the UPA government. Experts believe that some of the positive provisions such as extending the jail term, provisions to curb commercial entities from giving a bribe and fixing a time for trial can be seen as good steps. But still, there is a wide gap which would allow culprits to take a chance and escape the law. With cameraman Jiten, Dipali Pandit for Rajya Sabha Television.
The existing law provides for punishment with imprisonment for 6 months to 5 years. The bill now enhances the imprisonment to 3 to 7 years with fine. I'll start the discussion with you. The last point, the background part that you were mentioning. does the bill in its existing form or the amendments in any way deter a just public servant to perform or be dynamic enough? Or does this become a deterrent for him to make decisions?
No, Amritanshu, I think the problem we had with the older act has been addressed in the new act. Well, nobody can doubt that corruption, which is eating into the vitals of the society, has to be addressed seriously. Care should be taken that the sections of the act are not misused so that honest civil servants, who are the steel frame of the nation, are able to discharge their duties. Remember that if they don't discharge and they play it safe and they don't act, things will not move and there will be a paralysis. And that is why the Honorable Prime Minister, when he addressed the bureaucrats in early October, he said that he would ensure that honest bureaucrats are not prosecuted. And how has that been addressed? Earlier we had a provision which said, if there is a situation where a benefit has resulted to a third party, irrespective of whether any gain had ensued to the public servant, he could be prosecuted. And the investigating agency, which was not trained to investigate economic offences, because even now they don't have an economic wing in the investigating agency, was roping in civil servants who had awarded tenders, who had procured wheat from abroad, who had procured oil from abroad.
Any act.
So now, he had not had any gain. He had acted in the interest of the nation. Somebody has benefited because the supplier of oil has to get money from the government.
Correct.
And he was prosecuted, and the long trials, completely demoralized a civil servant. And the other civil servant said, now why should I take any risk? I will now play it safe. I will make an ambivalent note and leave it to the minister.
I'll get in Shakti Sinha. Shakti Sinha, what do you feel about this? Because the point that you were making is that the threshold for providing proof has also been hiked with the hiking of punishment.
Yeah.
Now, with that scenario in place, do you really see the points being made by Vishwanathan, Mr. Vishwanathan, really coming into a contradiction with that?
No, not really. I think Mr. Vishwanathan's point is a very valid point. The existing law is so perverse on that limited sense that if I do something in good faith, in the public interest, but if third party benefits by that act, I get prosecuted for crime. That is obviously out. But the threshold point is that earlier on, if I have an asset which is well beyond my known sources of income, then the burden of proof is on me to show, yes, I have legal source of income. Today, what happens in the amendment bill, which is not yet law, fortunately, in the amendment bill, not only has to be shown, the investigators has to show that I have assets or property beyond my known source of income, but that I had intention. Mens rea comes in. Now, when intention comes in, then the burden of proof obviously has gone higher and has shifted to the prosecution and not to the defendant. See, in a normal crime, it is the prosecution who has to prove beyond reasonable doubt.
Do you see that as a relief to the public servant or a negative
to me, that is a negative thing, because unlike a normal crime, where the prosecution must prove beyond reasonable doubt, here if on the face of it, X has earned 50 lakhs in his lifetime, X has property worth 75 lakhs, then X must prove where the 25 lakhs came from, assuming he did not eat all his life. That where did the 25 lakhs come from?
Correct.
Today, you have to also prove, the prosecution must prove that I had the intention to make money to acquire the property, which to me is not. So the other aspect which he mentioned is absolutely a very good aspect. This, unfortunately, is not.
Do you see it as a dilution or as a plus for the good, just bureaucrats to continue to make dynamic decisions?
No, this has nothing to do with just bureaucrats. I entirely agree with Mr. Sinha that the word intention in 13 should be deleted. And I can tell you that was the recommendation of the Standing Committee of Parliament. That once you own assets disproportionate to known sources of income, the intention is very clear. There's no need to further go and prove intention.
True.
It is with an intent to aggrandize that he has amassed wealth. So that should remain. That has nothing to do with honest bureaucrats fearing, because no honest bureaucrats need to worry about that part of the matter.
The second point you mentioned were all bribe givers in the same room. Now, what is it that you actually want to...
You see, supposing there's a person, I'm not justifying corruption, but I'm just giving a theoretical example.
Correct.
A person is in hospital, a family member needs to be operated, a life-saving operation. At that moment, the hospital staff approach him for a bribe. What would be the rational reaction at that moment? Will that person go to Anti-Corruption Bureau or CBI? Or will that person deal with the situation? In the existing law of the land, Prevention of Corruption Act 1988, if in court the bribe giver gives a statement which proves that bribe was given and therefore the person receiving the bribe can be convicted, that statement cannot be used to prosecute the bribe giver for abetment of crime because it has helped the law. So in that sense, while one should not condone bribe givers, one should also look into the circumstances, whether it was a collusive bribe or under coercion.
This is a very fine line. Do you see any provisions being made for this kind of a act in the present bill?
I think it should be made, and that's the recommendation of the Law Commission presided over by eminent Chief Justice Shah. Now, let me tell the public what happens in a corruption case, in a trap case. An Indian citizen goes to an authority for issue of a ration card. The Tahsildar or the RDO says, I want 1,000 rupees. He's a very righteous man. He doesn't want to pay a bribe because it's against his conscience.
Correct.
Now, what he does, he goes and reports the matter to the Vigilance Department. The Vigilance Department organizes a trap. He goes as a decoy with the money, with the connivance of the Vigilance Department, because he's going on their behalf.
Correct.
A phenolphthalein powder is applied, a chemical. When the public servant takes the money, and if that is dipped in sodium carbonate, the solution becomes red. And that's a proof in a criminal court,
Right.
along with the demand. Now, there was a section 24 in the old act which intended to protect people like him when they are examined in court. He says, I was asked, I paid. Now, protection was that when you say that you have paid, you should not be prosecuted.
That protection has been removed.
That protection has been removed. Wholesale, lock, stock and barrel. So, the Standing Committee and the Law Commission have said, make a distinction between, as Mr. Sinha said, coercive corruption and collusive corruption. And number two, people who go as decoys on behalf should be protected.
Right.
And I'll just add one sentence to it. The former Chief Economic Advisor to Government of India, Dr. Kaushik Basu, 3-4 years ago wrote a paper on it saying that please distinguish the bribe giver from the bribe taker if you want to bring down corruption.
Correct. Time for us to head into a break. When we come back, we will talk about the recommendations of the Standing Committee. Welcome back. Parliamentary Standing Committee on Public Personal Grievances has recommended that the government should define corruption and corrupt practices. The committee wants the government to amend the bill to include retired officials in the definition of public servant. This is because the bill extends certain protection for retired public servants.
The Standing Committee on Public Personal Grievances has recommended in its report that the provisions which include requirement of proving intention of public servant in a disproportionate assets case against him must be removed. They also stated that the inability of public servants to explain the source of his disproportionate assets should be sufficient for prosecution.
According to me, the whole framework of the Prevention of Corruption Act has been weakened, with the result that many scams will escape. And one of the things which has been weakened is Section 13(1)(d). Section 13(1)(d) made possible prosecutions in the 2G scam and the coal scam. If these amendments go through and that section is emasculated, then it is possible that a long and a large number of scams may escape detention, prosecution and conviction.
The committee recommends that punishment for habitual offenders must be enhanced from 3 to 5 years, extending to 10 years. It wants the government to prescribe trial timeline of corruption cases as have been prescribed in the Lokpal and Lokayukta's referred cases. The committee feels that there is a variation in punishments to commercial entities and individuals associated with the entities. The committee recommends that the punishment specified to the commercial organizations should be in addition to that specified for individuals in charge of the organization. The committee also recommends that the government should form rules and regulations to avoid cases of coercive bribery.
A lot of thinking needs to go in to not just the provisions of the bill, but also into what is the requirement as far as the infrastructure and the human resource requirement and the financial resource requirement for implementing this kind of law. And I don't find such a discussion in the Parliamentary Committee report, and I think it was quite hastily done, and perhaps it deserves a second round of consideration. And I'm hoping that now, with the 16th Lok Sabha being in place, that the Rajya Sabha and the Lok Sabha would together take a detailed consideration of this bill.
The bill provides for the inclusion of proving intention of public servant in a disproportionate assets case against him. The committee recommends that this provision be removed. The inability of public servant to explain the source of his disproportionate asset should be sufficient for prosecution. The Standing Committee on Public Personal Grievances submitted its report on the Prevention of Corruption Amendment Bill 2013 on February 12, 2015. The Standing Committee suggested that the pending bills like the Whistleblower Protection Bill 2011 and the Citizen Charter Bill 2011 needs to get enacted. In its opinion, if these bills get passed, it would address the concerns of those people who are forced to give bribes and would encourage them to report the acts of corruption. With cameraman Jitain, Dipali Pandit for Rajya Sabha Television.
The committee recommends that the minimum punishment for habitual offenders be enhanced from 3 to 5 years, extendable to 10 years, as this would ensure parity with the Lokpal and Lokayukta laws. Now, the question of trial time, the point that you wanted to make on trial time, is it really possible, given the burden that the judiciary is under, to prescribe trial times in a law?
Laws do prescribe for trial time. Of course, the courts are not really completely bound by it. But if you see a Corruption Act case being going on for 20 years, then the whole purpose of the law gets defeated. And frankly, I think even to the bribe taker, if he's punished after 20 years or 6 months or 2 years imprisonment, I think it's really a sad situation. We should, a trial time of 2 years, which the cabinet in a meeting of a few months ago,
Needs to be prescribed.
in the cabinet, the present cabinet, I think in April or so, did suggest changes to the act, has approved change to the act, which has to go to parliament, which says that the timeline should be 2 years.
On the 13(1)(d) that
Divan.
senior advocate Divan was mentioning, do you agree with that point? Because that needs a little bit of a clarification. There is a confusion on that part.
No, I entirely disagree with Mr. Divan, a very distinguished colleague of ours in the Supreme Court. The 13(1)(d) is addressed in section 7. Now, what is not addressed, and perhaps that is what Mr. Divan is referring to, is the old subsection 3, 13(1)(d)(3). I don't want to go into sections because the public shouldn't be, confused. Now, that was the section which created all the confusion and which resulted in the paralysis of the administration because the bureaucrats refused to take decisions. Honest import of wheat for the sake of the country resulted in bureaucrats, very eminent bureaucrats being prosecuted. I don't want to take names. Now, the only way that could be addressed was to say that unless there is gain to the bureaucrat or to a third person at his behest, he shouldn't be prosecuted.
But is that addressed completely, or there is still some loophole somewhere?
According to me, if section 7, as recommended by Chief Justice Shah in his report, is enacted and the present clause in the bill is substituted, the concerns are addressed, accused who are a part of the scam will never get away. Those who will be absolved is bureaucrats who take decisions in public interest, so that tomorrow they are emboldened to take a decision rather than, playing it safe. I think this is a very serious issue, and sooner it is addressed, the country will not be able to progress.
On the commercial side, they have clearly the commercial entities that are there, now the ambit has been increased. Earlier, it was limited to just some business entities and things like that. The wording was, the drafting was not as expansive as it is now today. But the highest in the commercial entities have been given an escape route if they prove that they had no knowledge.
A little more than that. It's not just knowledge. Of course, the chief executive is responsible, but if he has adequate mechanisms in place. Now, companies are very big companies. You're a company of 10,000 crore turnover. Chief executive would not be knowing every single transaction. But if the company has sufficient, and the law does not define what it is, internal mechanisms to check these malpractices, then the chief executive cannot be prosecuted. But the company does not have any internal mechanism which say we shall not pay bribes, we shall not do this, and if we do this, we shall be kicked out of the company, etc. Then he can be prosecuted.
So this is a positive change. This is a positive
half and
amendment.
half.
I think it's a welcome change, except that, as the Law Commission points out, in the anxiety to make the bill comprehensive, some provisions from the UK Act have been lifted. Now, the Act in the United Kingdom applies even to private persons. Our Act is for public servants. So, necessary tweaking have to be done in the bill, but punishing the higher management per se may not be the correct thing to do. Don't forget that middle level management executives do have incentives if they perform and if their department procures a particular contract, and that could be a sufficient incentive for him to suo moto, resort to illegalities. The higher management sitting here or sitting abroad would really not know as to why this has been done. So an internal mechanism has to be provided by them as to what it should be has to be clearly defined.
Okay.
And once that is done, that should be a defense available to them in the trial.
Codifying corruption and corrupt practices. How easy or difficult? Quickly.
No, I think you really don't have to codify corruption to my mind, though it has been recommended. You have laid down what is misconduct, wrongful misconduct, which is seeking a favor or obtaining an asset either for yourself or somebody at your behest.
Correct. That's a comprehensive.
Once it is good, I think that is good enough.
What about corrupt practices?
No, this is covered by
Same.
that, because anything that you do in an improper manner against the public interest
Is covered.
is basically covered. My worry is if you get into too much definition, people will find escape routes.
And in fact, the problem with the law is the more the codification, the more
The escape routes.
effective the law will be. On the codification of corrupt practices and corruption, do you think required, not required, should be there, not be there?
No, I don't think we should get into any exhaustive definition. The existing definitions take care of it. Gratification, undue advantage is the word suggested. Undue advantage will include monetary advantage. Even a sexual favor would be covered. So the existing laws take care of it. The problem which too much drafting is the old adage, I am the legal draftsman, I make the country's laws, and for half the litigation, I am undoubtedly the cause.
Moving on, my colleague Dipali Pandit spoke to Prashant Bhushan, advocate, Supreme Court.
So, do you see any shortcomings in the bill?
The bill, instead of adding a section on conflict of interest, for example, prohibiting or penalizing a public servant who takes up a job after retirement with a company whose file he has dealt with as a public servant, which is a serious problem which needs to be penalized. Instead of doing that, this bill has diluted the present provisions by deleting section 11, which says that if you are a public servant dealing with a file of a particular person or a company, and thereafter if you take any valuable thing or consideration from that company, that's an offense. Instead of strengthening that, they have deleted this altogether. Then section 13, which deals with criminal misconduct, that has also been diluted. There were two provisions which said that if you give an undue benefit to a private company or a private person without any public interest or by abusing your position as a public servant, that was an offense of criminal misconduct. That has been completely removed. And the only thing that is left as an offense is taking a bribe or being in possession of disproportionate assets. So it has very seriously diluted the Prevention of Corruption Act.
So what will be the impact of such amendments in fighting corruption?
I think it will have a very negative impact. I think by this the government wants to send a clear signal that it is quite all right to be involved in conflicts of interest. It is quite all right to accept valuable things from persons that you are dealing with in your official capacity. It's quite all right to abuse your position as a public servant and benefit a private company, etc. It's a very bad signal that is being sent.
Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.